invite Professor Barrett to come up.
What I want to do is get started so as to leave a little time for questions at the end, not only of me, but also of Judge Chin and others, so that we can complete the conversation with everyone, having digested the morning's proceedings, which already have been extremely rich. I'm John Barrett. I'm a law professor at St. John's University in New York City. I'm the Elizabeth S. Linné Fellow here at the Jackson Center and a member of the Jackson Center Board, and I'm a Robert Jackson biographer. I think many of you are on my Jackson list, which is occasional emails, but if you're not and you wish to be, just give me an email address. And there's one percolating on the back of the stove, which will come in a few days. I had the great privilege through the Jackson Center in 2002 to meet Fred Korematsu and Catherine Korematsu, and to be part of a program with them at Chautauqua Institution, and also part of an interview and a visit here at the Jackson Center. And then I stayed in touch with them, and I was part of another conference with them in 2005 in Los Angeles. Karen referred to it. It's when I actually met Karen for the first time. And Fred's health was clearly beginning to fail. He was frail, but even in his frailty, the moral clarion was extremely clear. Since then, I have been parts of programs with Karen, and I have written about the Korematsu case, growing out of that Los Angeles conference. I wrote an article about Justice Jackson's dissent, which I reread in preparation for this. It will be in your CLE materials, and I was relieved to find, after these years and knowing more now than I knew then, that it holds up pretty well. So among other things, I urge you to, after today's stimulus, dig deeper and read and explore, and that's one thing that you may wish to consider. So my topic is the ongoing challenge of deciding Korematsu. And I have that framed in the present tense because I think that's where we are. We are part of an ongoing challenge of us deciding Korematsu. I'm going to approach this in four areas or topics. How the Supreme Court, back in the 1940s, decided the Korematsu case and the other Japanese-American cases during World War II. How Justice Robert Jackson, in particular, dissenting, decided the Korematsu case in 1944. The modern assessments of Korematsu and that body of decisions. And then, if I may, a kind of mixed conclusion that I take away from all of that. So first, how the Supreme Court decided Korematsu and the other Japanese-American cases. There were three military policies at issue, promulgated by General DeWitt, pursuant to the authority conferred by President Roosevelt under the executive order. There was the curfew, then there was the exclusion from the coastal areas, and then there was the deportation, incarceration, internment is the most familiar term, but it's really a term that was actually picked by the War Relocation Authority. It's the softest way to talk about concentration camps. And those are the three legal issues, curfew, exclusion, internment, that made their way to the Supreme Court. Not at first. These policies all began in 1942, and if you look at the record of the federal courts, even at the lower levels and certainly at the U.S. Supreme Court level, crickets. Not cases, not judicial opinions. In other words, the government was doing this to Japanese Americans, and courts were not dealing with it during the first months, nearly the first year. It's 1943, the second full year of American involvement in World War II, and the second full year of military policy on the West Coast, that sees cases begin to make their way to the U.S. Supreme Court. And there are three that you've heard about this morning. There's the Hirabayashi case, which raised the questions of both curfew and exclusion. There's the Korematsu case, which raised the questions of both curfew and exclusion. And there's the Yasui case, which raised, again, the issue of curfew. The Supreme Court hears oral argument in those cases in May of 1943 and decides them a month later, in June of 1943. Robert Jackson is a member of this court, and it is a court that decides all three of these cases unanimously. It decides the Hirabayashi case by chopping off the exclusion issue and leaving that for later, for some other case, and treating it as merely a case of curfew because Hirabayashi's sentences were concurrent for violating those two measures. And in that case, the court unanimously upholds the validity, the constitutionality of the race-based, the ethnicity-based curfew system that Hirabayashi was convicted of violating. Robert Jackson is part of that unanimous court. In the Korematsu case, the first Korematsu case, the case went off on a procedural issue, which was whether his probation without sentence was an appealable final order, as Kathy mentioned. And so the Supreme Court punted back to the Ninth Circuit what we should call Korematsu 1. And when it comes back, we'll talk about Korematsu 2, the meaty case that we've been talking about today. And in the Yasui case, having upheld the curfew in Hirabayashi, it was treated as a companion, and so his conviction for violating the curfew was also affirmed. Now, the Supreme Court in Hirabayashi, the big opinion, was very clear repeatedly to say it was only deciding the constitutionality of the curfew. And as impositions go, it's not nothing, but it's not more draconian than what it is. A restriction in your ability to be out and about after 8 p.m. Until 6 a.m. the next morning. A year later, the court decides two more cases. The first is, of course, Fred Korematsu's case, Korematsu 2, because after it had been held in the first case that this probation sentence was appealable, the Ninth Circuit decided the appeal and affirmed the conviction, and the Supreme Court took that case back. And as you've heard, of course, the Supreme Court 6-3 affirmed that judgment, that Korematsu's conviction was valid for violating the exclusion order. In other words, the exclusion issue that had been cleaved off of the 1943 cases and saved for later had been saved for Fred's case, and now it's decided on the basis of Hirabayashi. Oh, just like the curfew is reasonable and constitutional, so is the exclusion order, says the court in December of 1944. And in the last case, the one you have not heard about today, the court confronts the third issue, the internment issue. That case is called Ex Parte Endo. Ms. Endo was of Japanese-American extraction. She was an incarcerated inmate in a concentration camp. And she was, according to all government evidence and belief, a conceitedly loyal person. And in her case, decided concurrently with Korematsu 2, upholding the exclusion system, the Supreme Court unanimously declared illegal the internment system. Now, how have you never heard that the Supreme Court struck down unanimously the legality of the internment of the Japanese Americans? Well, it's because it happened on December 18th, 1944. In other words, by cleaving these questions into sequences and kicking the can down the road, in effect, the Supreme Court was doing a mop-up operation after it ceased to matter. It's the same day they decide Korematsu 2, and you've heard that Fred is in Detroit and working as a welder again and meeting Catherine. How is that? Because the camps were paroling people out the back door, and the military necessity and, frankly, the bureaucratic energy for this was dissipating, and the government wanted to get out of the internment business. And the Supreme Court basically gives them the legal approval by closing the door behind them. Now, how did Robert Jackson assess all these cases? Part 2. Well, it was a multi-year process, not just for the court as a whole, but for Robert Jackson as an individual. In 1941, he was a new justice, new to the court, from FDR's cabinet, where he had been Attorney General. And the first case that he confronted actually raising these questions of executive power and military power was not one of the Japanese-American cases. It was a summer 1942 case about Nazi saboteurs who had been captured on American soil, 4 on Long Island and 4 in Florida. And we're in the war. It's a declared war. This is the Atlantic War. These are sub-launched saboteurs who have been apprehended, really because a couple of them got cold feet and turned in the others, who are seized by the FBI, who are transported to Washington, and Franklin Roosevelt convenes a military tribunal to adjudicate their guilt under the laws of war. The civilian courts are open, but the president and the military are doing a military tribunal on the 5th floor of the U.S. Department of Justice. And during a special summer session in 1942, brave military lawyers representing these Nazi defendants sought writs of habeas corpus and got that case before the Supreme Court. And the court is being asked, is it legal for the president to do this special court, military court, hurry-up court, death penalty court, rather than the regular civilian courts which are open just down the block? And the Supreme Court holds unanimously that yes, it is. In times of war, based on security need, the president may do what he feels is reasonably justified under the laws of war. Robert Jackson is part of that 9 after much agonizing. You see, that's really when he begins to confront civilian court and claim of enormous presidential power. How far does that go? And when he tries to go too far, what can we, civilian courts, do to stop a wartime president? Jackson drafts, in that case, ex parte Quirin, a sort of concurring opinion teetering on the brink of a lightly dissenting opinion, and he works it and he reworks it, and then he puts it in his file and doesn't use it, and votes with Chief Justice Stone and the rest of the court, which upholds the military commission, which soon convicts all 8 of the saboteurs, and 6 of them are promptly executed, even before the court had finished writing its full opinion. So that's Robert Jackson in the summer of 42 beginning to think about these kinds of presidential claims. The next year, 1943, you'll remember, is the year of Yasui and Hirabayashi and Korematsu 1, and the court cleaving off exclusion for later, but deciding curfew. And in the context of the curfew case, Robert Jackson resumes agonizing, reflecting, thinking deeply, and drafting about what constitutionally a president may do in time of war based on a security claim. For the Hirabayashi case, Jackson drafted 8 successive versions of an individual opinion. In the end, you'll remember that he's part of the unanimous court that upholds the curfew. But before he votes without ever publishing any writing, he's drafting and drafting and drafting and drafting and agonizing and drafting some more. The first draft is a dissent. The court, it seems, he anticipated was going to uphold both curfew and exclusion, and Jackson is preparing to dissent from that. Then the court cleaves off the exclusion issue, and Jackson switches it to a concurring opinion in the upholding of the curfew, but emphasizing the discrete, limited nature of the imposition that a curfew imposes in the interest of national security. And some of the drafts are quite long, and lots is then crossed out, and it gets shorter, and it gets changed, and it goes back and forth and back and forth. And at the end of that process, he puts it in the file and gives his vote to Chief Justice Stone and does not write. A year later, out of that file comes all that work product, and that's what becomes his Korematsu dissenting opinion, Korematsu 2, our Korematsu. Professor Dennis Hutchinson of the University of Chicago Law School has written an article that does a lot of the archaeological work through the archives that traces this project. In that Korematsu opinion, issued with the decision as a dissent in December of 1944, Justice Jackson confronts 2 issues. And this is the difficulty for him, the difficulty in the Quirin case about the Nazis, the difficulty in the Hirabayashi case about the curfew, now the difficulty in the Korematsu case about the exclusion order. Leave the West Coast and report to the racetracks for further handling. First issue, the due process question. This is pure racism. The due process clause in the Fifth Amendment, which constrains the federal government, contains implicitly an equality command, an equality principle. And may the country, whatever the need, draw lines and pick subjugation based on race. And Robert Jackson says no. If we, a court under the Constitution exercising Article 3 power, confront that question, the answer is easy. And you've read, Tom read in the reenactment, the ringing words in Justice Jackson's dissenting opinion that our criminal process does not permit the criminalization and the transplanting of persons based on race. Easy, flat, unconstitutional. But that's only half of it. The other issue that Jackson confronts in his dissenting opinion is the question of judicial power. What a, if I may, small, robed civilian court can do in the face of the president with the army exercising its power in wartime. A slight glimpse of that part of his opinion was in some of the material that Tom read in the play. But it goes on for a few pages. It's the bottom half of his 6-page dissenting opinion. Because what Jackson does is compares the relative power and the relative powerlessness of president with military to civilian court in wartime. And that's where his concern about bad precedent is really developed and aired out. You see, he says, it's better for us not to try to stop the president when we're going to fail. It's better to abstain, if you will, because we are a civilian court and a military measure is done by the military. But if we're going to get involved, we shouldn't be dragooned into approving it, because what we decide is the meaning of the Constitution. And we will thus be creating a precedent in our constitutional law, which will lie around like a loaded weapon, and you know the rest of the beautiful quotation. Side comment, Robert Jackson from these parts knew guns. He had guns in his home. One of his pistols is over in the Fenton History Center across the valley. And I'm sure, as a matter of sensibility and family safety and all that, Robert Jackson did not leave loaded weapons lying around. He also had ammunition elsewhere. But a precedent by the Supreme Court saying an excess by the executive and the military is constitutional puts the bullets in the gun and puts the gun in the pages of the U.S. reports as a precedent of the U.S. Supreme Court. And Robert Jackson was appalled that the Supreme Court had done that because he was living it. Because what the 6 justices in the majority were doing in Korematsu was using Hirabayashi, which was supposed to be just a curfew case. And Chief Justice Stone in that opinion emphasized 3 different times, this is just a curfew case. Until a year later, the hand of authority, the Justice Department, reached for a precedent, Hirabayashi, to justify exclusion in Korematsu, and then all of a sudden, the Hirabayashi precedent was much more than a curfew case. If we are to abstain, if we, the civilian court, are not going to be dragooned to be a rubber stamp and destroy our constitutional law in the process, then the president and the military are going to get away with it, is the last thing that Jackson confronts in this opinion. And he expresses there a confidence that is striking and optimistic and perhaps naive. He expresses a confidence that this country is led by presidents who will be war leaders and victory pursuers, but people restrained from excesses beyond that. And when victory is won and when security is achieved, our leadership will reel back in measures that are controversial and hard in wartime. Especially because, second part of his confidence, we, the American people, choose such representatives by our engaged citizenry, by our participation, by our voting. And thus, if the court takes a step back, it's not that nothing opposes or constrains presidential power. Presidential caliber constrains presidential power because we elect presidential caliber. Part 3, the modern assessments of Korematsu and all. The bottom line, before I go through a couple of specifics, is that to the public, to all of us, the Korematsu decision was and is wrong, bad, an act of villainy. To look at it in any hindsight is to give Fred what he was really asking for, an individual hearing, and see that this man is nothing but an admirable, loyal, patriotic citizen like any of us, who is entitled to the constitutional rights not to be made a criminal because of who his ancestors happen to be. Easy question, if we're going to get into that merits question. But here's how the assessments have gone chronologically about Korematsu in what I'll call the modern era. I guess I'm talking about after the 40 years have passed. In the coram nobis cases, the reopenings in the 1980s, the trial courts, Judge Patel and the other trial courts, focused on Department of Justice villainy, that a fraud had been perpetrated on the court. The internal documents that Peter Irons and others had pulled out of Department of Justice archives that illuminated the brief writing process, the footnote issue and how brief and kind of inscrutable it became, the oral argument records that were belatedly discovered, showing that the Justice Department was not confessing error, was not pleading guilty, was not throwing General DeWitt on the table and saying this man's a racist, but was instead saying he believed there was a security measure here, and the president may have his general do so, was the Department of Justice position. And that was an injustice, which Judge Patel treated as conceded by the Department of Justice and thus granted the writ. A second phase of the modern assessment is the Department of Justice, despite its passivity in those cases, actually disagreeing quite vehemently with that account of its villainy. In those litigations, as best or as passively as he did, Victor Stone, with headquarters leaving him dangling in those cases, and others, did not think that the Department of Justice was the villain here. And subsequent reviews in litigation, including a case that went to the Supreme Court in the late 1980s, the Hori case, involved massive assessment by high-level career people, et cetera, in the Department of Justice that found that the justice of granting the writs wasn't to be called into question, but the claim that the Department of Justice had committed fraud on the Supreme Court was unfounded. And there is an ongoing, complex scholarly debate with lots of active writing based on Peter Irons' work and books and much more since then that continues to debate this. And really what it is a scoring of the candor or lack of candor of Charles Fay and others in those cases. But it is not an easy question to answer with certainty and render a verdict of 100% dishonesty with regard to the Department of Justice. A third phase in the modern assessment is my friend, Acting Solicitor General Neil Katyal's 2011 statement, which you've seen earlier in this presentation. It is an apology for and a personal denunciation of Charles Fay, the Solicitor General. F-A-H-Y, pronounced Fay, was the Solicitor General during this time period for the entirety of World War II. And Neil's argument in that statement is basically an echo of Judge Patel's opinion of injustice and the scholarly assessment of the lack of full candor that is certainly a fair thing to describe as what Solicitor General Fay did in those cases. But what it omits, and I offer this just as some context to consider, is a little bit about who these people were. So let me tell you about three very close friends: Robert Jackson, Charlie Horsky, and Charlie Fay. In other words, the Justice and Fred Korematsu's attorney and the Solicitor General of the United States. Because in this play, you're looking at three men at the end of 1944 who are teammates less than a year later doing the Nuremberg trial. But before we get to that, Charles Fay, Middle America, World War I soldier, gassed, tuberculosis, wasn't supposed to live, went to New Mexico, miraculously lived, came back and becomes a New Deal lawyer and rises up through the National Labor Relations Board to be in the Department of Justice. And then after Jackson becomes Attorney General and Francis Biddle becomes Solicitor General, and Jackson goes to the court and Biddle becomes Attorney General, Fay becomes Solicitor General, and was a revered, excellent, straight shooter advocate in the eyes of the court, the public, his peers, during those 4 years as Solicitor General, which include these cases, which might be exceptions to that general pattern or might be something to think about. One of the jobs he did just before he headed the Department of Justice Solicitor General's office was to head the aid effort implementing the destroyer deal that Robert Jackson had provided the legal advice for, which was Franklin Roosevelt saving Winston Churchill and the British Empire from the U-boats. Charles Fay both crossing the Atlantic and in Washington, makes those destroyers get to Great Britain. In 1945, after the German surrender, Fay steps down as Solicitor General, and he, like everybody else, at least in this action group, goes to Germany. He's the principal legal advisor to General Lucius Clay in Berlin. And so the Jackson prosecution effort down in Nuremberg, in a sense, reports to Berlin because it's part of the occupation effort. And Charles Fay is in Nuremberg all the time, and Robert Jackson is in Berlin all the time. And Charlie Horsky of Covington and Burling is running Jackson's Washington office in the Pentagon, except when he travels to Nuremberg and Berlin. And yes, they probably even had a few beers together, but lots of personal interaction and high regard. 9 months after this Korematsu saga. And then let's move forward. In 1947, Harry Truman, the president, assesses what we're to do with our segregated US Army. And he appoints a commission, but the point person to evaluate that is Charles Fay. And Charles Fay urges the immediate, forthwith desegregation of the US Army. Harry Truman gets credit for it, but Charles Fay is the voice who demanded it. And then the next year, he's appointed to the DC Circuit, where he served with great distinction as a US federal judge for 30 years. And in that time of prejudice, if he hadn't been appointed that year to the DC Circuit, he would have been available the next year when the Catholic seat on the US Supreme Court opened up with Justice Frank Murphy's death, and undoubtedly Charles Fay would have been made a Supreme Court justice. Now, he died in the late 1970s, just before the reopening and reassessing of the Japanese-American cases began. It would have been most interesting to see, if he'd had 5 more years, how the historical assessment would have worked on him. A fourth phase of the modern assessments is the US Supreme Court. Before we get to the Trump versus Hawaii decision, the US Supreme Court for decades is silent about Korematsu versus United States. It's an uncitable, unmentionable in the US Supreme Court. Off the bench, every justice, once you tally it up, finds an extrajudicial opportunity to speak about and to denounce Korematsu. So you can kind of count recantation votes off the bench, but nothing's happening in the courtroom. Nothing is happening officially to that. And then we get to 2018. And you've heard the story of Trump versus Hawaii, how Justice Sotomayor's dissent and her equation of what the majority was doing to Korematsu prompted Chief Justice Roberts to disagree. And while he was there to overrule Korematsu, an interesting piece of dicta. But in that moment, whatever it amounts to, something quite desirable happened. Because the US Supreme Court identified, faced up to, the culprit, the ultimate government actor culprit above General DeWitt and the West Coast military for Korematsu versus United States. It was the court itself. And whatever the status of an overruling by dicta is, the court itself, which clearly knew that there were no flock of prosecutions of Japanese spies, that there were no Japanese American citizens performing acts of sabotage, that the paroling out of the camps and the winding down of the War Relocation Authority was happening, that the invasion of the West Coast was not happening in 42, 43, or 44. The Supreme Court that had decided these cases in the 40s faced up to, and as best it could, fixed in name that behavior by it in 2018. That brings me to my mixed conclusion. We have said goodbye to Korematsu, the decision, the one in the book here, but we have Trump versus Hawaii. And it is a decision of judicial deference to executive power in the realm of border control, immigration, national security, and terrorism prevention, made not even in wartime, or perhaps, there's complex definitional questions here, made in the wartime of the sense that we live in and have lived in since 2001, and I guess we'll always be living in forevermore, the forever war, and 5 justices, a decision of the Supreme Court says, in that context, the president, with an articulation of a security rationale, gets judicial deference. That is a precedent, a decision on executive power that, of course, now lies about like a loaded weapon, whatever the status of Korematsu is. And we have swirling around us the social, political, legal contexts that produced both Korematsu back then and Trump versus Hawaii now. Meaning, we don't all look alike. We come from different places. We have our inscrutable differences from outside of religion and culture and food and music and language and dancing and, you name it, right? And some of it becomes great and familiar, go down to the taco hut, and some of it remains much less familiar. And these are closer to us, and those are others. And then when scary things start to happen, if it looks like others might be involved, the instinct to wall and to react and to do things that are dramatic isn't just a 1940s issue, it's us. So what to do about that? And I'm speaking now about judges, sure, when something becomes a court case, but I'm really speaking about all of us, what to do about that. What do you think I'm going to finish with? I circle back to Robert Jackson's dissent in the Korematsu case. I think we should face the issues as he faced them in Korematsu. Face the due process question, meaning the racism question, the inequality question, the Fifth Amendment question. When the government is acting based on race without an unimaginable justification, theoretically a compelling state interest in a very narrowly tailored measure could satisfy the Constitution under our current doctrine, but I don't know what that fact pattern is. So by and large, that's unconstitutional. That's not us. We shouldn't do it in the first instance, and if it's happening, we should litigate against it, fight against it, be Charlie Horsky, be Owen Roberts, Frank Murphy, Bob Jackson, etc., and enforce the Constitution. We should also, more pragmatically, and maybe this is the depressing side of this mixed assessment, face the judicial power question. With presidential, military, security, immigration, law enforcement powers, and those are enormous, what really can the role of a court be to make it stop, to constrain it, to make it better, to fix excesses? Probably, as Robert Jackson was agonizing through Quirin, through Hirabayashi and Korematsu, and across the rest of his life, not very great. But his ultimate backstop is still there, and that's us. We need to face our political responsibilities. We need to be, as best we can, the citizens and voters that he optimistically, naively, beautifully thought that we were in the 1940s, or could be, maybe that we are or can be these days. As we vote, as we engage, as we learn, as we study, as we speak, as we pick our representatives, as we choose our policies, as we support acting one way and correct errors when we've made mistakes and gone the other way. And finally, and I think this is in Robert Jackson's dissenting opinion too, really quite directly, we need to see the real human beings. We need to face the people that we're talking about. These aren't abstract questions. This isn't Japanese Americans, some blob of 120,000 others. This is individuals like Fred, who I got to meet, who was lovely, charming, real, brilliant. People often say he was a simple man, in a sense, but also a very smart, simple man, a very deep, simple man. And here's a closing phrase that I used when I wrote about this and that sticks with me always. We sat down here and had a conversation with him, Greg Peterson and I, Catherine, Eric Fournier, the filmmaker. And Fred, whose health was already starting to get a little bit wobbly in that year, 2002, was asked about his case and how he thought about the court, the 6 justices, and the dissenters, and if he had thoughts about Robert Jackson. And Fred Korematsu used this incredibly lovely phrase. He said, "I was so glad that he was one of my lawyers." Which, of course, he wasn't, right? He was a justice of the Supreme Court. But I think what Fred meant in referring to Robert Jackson and Frank Murphy and Owen Roberts as his lawyers was that they sort of got it and they acted on it. And that's the challenge for each of us. Keep our eyes open, keep our ears open, keep learning, get it, and then act upon it. Thank you very much. If there are questions, I think there are a couple of minutes for Judge Chin or Kathy or myself. Yes.
The case of ex parte Endo,
Yes.
the German spy, was the holding limited to extra nationals, that is, not American citizens?
It was limited to violators of the laws of war, which these ununiformed saboteurs landing on foreign soil were under American constructions of the laws of war. I think a domestic terrorist could perhaps qualify, but anybody not in uniform coming to commit acts of sabotage would be covered by what the court viewed as the crime that the executive had the ability to try in the military commissions. Judge Chin, Kathy Chin, the Robert H. Jackson Center. I just took my shot at it. Lots and lots of people. Jamestown High School and the middle schools and so forth are filled with people doing it. And at the dinner table tonight, moms and dads are going to be doing it. I think there are a lot of teachers. We just need to remember to, be good teachers, try and get smarter. And to do it. There's nothing but history, is my view. Otherwise, you're just surfing along in a fog. So I think it is the thing to study and to share.
Thank you for sharing.
Judge Chin.
Great presentation. I have a question. How do you think Justice Jackson would have decided Trump versus Hawaii?
I smile because I do get the "what would Robert Jackson do" question a lot, and I so wish I could have one Ouija board moment with him, but have never had that. I think it is a hard question if one looks at his decisions about executive power in the abstention argument, and if you look at some of his decisions in the immigration area, he might well have been deferential to executive power. I suspect that his desire to decide things on a modest ground would have led him to write a concurring opinion and try and narrow the deference to some very specific constellation of facts. But his instinct was judicial restraint. He was not a maximal justiciability jurist. He believed that this was a great liberal democracy of a country. And so the executive and the voters could fill the gap, except in special instances like Brown versus Board of Education, where, of course, he's one of the 9, where it's appropriate for a judicial role. So I think for him, it would have been not an easy case. I suspect he would have probably drafted 8, 9, 10 opinions and gone back and forth on whether it was dissenting or concurring. Thank you all very much.